Ladies and gentlemen, welcome to the CIL eAcademy and this week's guest lecture by His Excellency Judge Rüdiger Wolfrum on the topic, Are international courts and tribunals procedurally well suited to enforce community interest-oriented regimes? Allow me to now introduce the co-director of the eAcademy and director of the Center for International Law, Dr. Nilufer Oral.
Thank you so much, Zue, and greetings to all of you, and welcome again to one of our wonderful distinguished speakers lectures of the eAcademy at CIL. And today we are particularly honored to have Judge Rüdiger Wolfrum. And I'll start off by this. Most of us study international law, research and write, but you have on occasion someone like Judge Wolfrum who actually has shaped international law. So it really is such an honor to have him with us today. He's a professor of international law at the Heidelberg University Faculty of Law and director emeritus of the Heidelberg Max Planck Institute for Comparative Public Law and International Law. But I first met him when he was judge at the International Tribunal for the Law of the Sea, and he was a member of the tribunal. He was actually part of the very first judges who were elected to the tribunal from 1996 to 2017, and he served as the president of the tribunal from 2005 to 2008. He remains very active, I know, as a judge on many arbitration cases. He is also board of directors of the Rhodes Academy for the Law of the Sea, a member of the Institut de Droit International. But Judge Rüdiger Wolfrum is not just law of the sea, it's international law, all subjects. He has countless publications. And I can go on and on and on, but we want to save our time to listen to his wonderful lecture today. So Judge Wolfrum, the floor is yours.
Thank you very much indeed, Nilufer, for your kind introduction. And I appreciate very much to be asked to give this lecture. I have a very strong affiliation to Singapore, and therefore I'm very pleased to be with you. There's only one, dismay, if I may express. I would rather be in Singapore than in Germany in the moment. I will lead you through this lecture by being a little bit critical about the existing dispute settlement system. You will bear with me. You may take a different view. That is appropriate for an academic discussion. International courts and tribunals are, and you will all agree, tailored to decide in contentious proceedings upon international disputes. But what is an international dispute? According to general accepted standards as established by the Mavro Martis Clause, modified by the International Court of Justice, I'm going back to the Permanent Court of International Justice, an international dispute is, and I quote, a disagreement on a point of law or fact or a conflict of legal views or interests between two persons, and it must be shown that the claim of one party is positively opposed by the other. End of the quotation. It will be demonstrated in this presentation that this view on what constitutes an international legal dispute forces disputes into a procedural straitjacket. This is hindering international adjudication on disputes concerning the implementation of international treaties serving community interests to function effectively. The ICJ, and that is a positive side of it, has cautiously taken steps to ameliorate the procedural restraints originating from the amended Mavro Martis Clause. Now, briefly, what are community interest-oriented treaty regimes? It is well established in practice and confirmed in academic writings that community-oriented regimes exist. Community interest-oriented regimes include, just to give you some examples, human rights regime, the regime concerning the protection of the environment, and the one concerning preservation of peace, for example. The last one is the most ancient one on the environment, including climate change, the most recent one. The reference to common interest is, by the way, not at all aligned to international law. The contrary. Francisco Suarez, 16th century, argued already that international law aimed at the conservation of justice and peace between states in order to preserve the common good of mankind. My computer always changes that word into humankind, but Suarez still spoke about mankind. I have to apologize for that. The idea that common interest should be taken into account in shaping international relations was overshadowed and marginalized by the dominance of the principle of state sovereignty as a structural principle of public international law. But let me also underline that Vattel, for example, already spoke about common interests and the obligations which are to be drawn therefrom, in particular in respect of diseases or earthquakes or whatsoever. Establishing regimes designed to serve community interests have to have a legitimizing dogmatic basis. The basis has to be achieved by two factors, a procedural and a substantive one. Both must coincide and needs a supplementation of an adequate dispute settlement system. It is a logical consequence that regimes serving community interests must be established in a procedure which is open for international participation, and I mean a worldwide participation. In the recent period, such regimes were mostly initiated by resolutions of the UN General Assembly or by international conferences in which all states, as well as all forces from the civil society, were able to participate. The participation of the civil society is enhanced in international conferences. I just would like to point out to the Rio conference. Additionally, the regime in question must be adhered to by a representative, and I underline the word representative, group of states which are convinced that the regime concerned is necessary, for example, concerning environment or world climate, or ethically required, for example, human rights, including genocide, to which I will come in a moment, common spaces, which by their very nature must be open to an international community, require an adequate management system which allows the community to participate. The most challenging aspect, however, is to preserve the legitimacy over time and in respect of progressive development of that regime in question. Please take into consideration how the regime concerning preservation of peace has changed since 1948. One of the earliest references of international jurisprudence to the existence of community interest is in the statement of the International Court of Justice in its reservations to the Conservation on the Prevention and Punishment of Crime of Genocide advisory opinion. The court stated that in such a convention, and I quote, "The contracting parties do not have any interest of their own. They merely have one and all a common interest." End of quote. This approach was honored in the case brought by the Gambia against Myanmar by the ICJ in its order on provisional measures of 23 January 2020. I'll come back to that. The International Court of Justice less successfully touched upon the acceptance of community interests in respect of whaling. In the case concerning whaling in the Antarctic, Australia versus Japan, New Zealand intervening, The court, although being aware of the international scientific and ethical differences concerning whaling, stated that it did not consider it its mandate to rule as to whether the protection of whales had become an international community interest enforceable even against those which had not adhered to the whaling regime. This self-restraint was a tribute paid to the bifocal character of the legal dispute between Japan and Australia, or Australia and Japan, while totally ignoring the community interests in the preservation of whales. Now, let me come to the question, is the international dispute settlement system adequately shaped, or can it be improved? As already indicated in the first sentence of this contribution, at least two inherent limitations to the traditional settlement system make it problematic that this system develops its inherent potential fully. Only very few international regimes serving community interests provide for mandatory recourse to judicial dispute settlement. Apart from that, it is widely held that states may only invoke the violation of their own interests. That's a question of standing, rather than the interests of the international community. Let me come to a more factual issue. Most international human rights treaties provide for the possibility of an interstate complaint procedure. It is a fact, though, that at the international level, states do not have recourse to such procedures, which are mostly contentious. One can only speculate why this procedure is not being used. The fact that it is contentious cannot be of relevance. For the procedure which is provided for by the International Convention for the Elimination of All Forms of Racial Discrimination provides a mechanism which is not contentious. It's more like an advisory opinion or conciliation. It's nevertheless not being used. Article 9 of the Genocide Convention provides an alternative to an interstate complaint procedure to which the ICJ in the legal dispute between the Gambia versus Myanmar referred to. According to it, disputes between contracting states relating to the interpretation and application of fulfillment of the Genocide Convention may be submitted to the ICJ. The potential of this procedure has been clearly demonstrated by the order to which I already referred. The relevant element is that Gambia did not have to claim the violation of its own interest. Let us not forget, the Gambia was very far from Myanmar. But the Gambian case is not the first one. The ICJ had already followed the same approach in the legal dispute between Belgium versus Senegal. That was a matter of torture or the application of the Convention Against Torture. The ICJ argues pragmatically that in most situations, no state would be able to claim the cessation of the alleged breaches. The decisive point for the ICJ was that the Convention Against Torture served community interests and that, accordingly, each state party has the right to claim the cessation of the alleged violations. There's more agreement on the merits than on the procedural point, which proves my criticism. Let me move to another element. Dispute settlement regimes under environmental treaties. Most multilateral treaties concerning the protection of the environment, as well as the ones on common spaces, contain a dispute settlement clause or, as UNCLOS, a very elaborate dispute settlement system on which I will talk in some detail. The dispute settlement clauses of multilateral environmental agreements display a rather remarkable homogeneity. They all provide for a general structure, namely the states parties shall solve disputes with respect to the interpretation or application of the treaty concerned through negotiation or other peaceful means of their choice. If no settlement can be reached, the dispute may be submitted to the ICJ or arbitration with the consent of the parties concerned. There are some minor varieties, but that's the gist. None of these arbitrations has ever been used. I'm on the panel for arbitration in this context. Nobody has ever brought a case. And if you look through to the jurisprudence of the ICJ, you don't find anything there. There's very few environmental cases. The reason is none of these regimes provide for a mandatory recourse. The main deficit of these clauses are evident if you compare them with the already quoted Article 9 of the Genocide Convention. But even if a unilateral recourse is possible, such as under UNCLOS, it doesn't work well. And that will take a couple of minutes to explain. UNCLOS establishes a very differentiated system for the settlement of the law of the sea disputes. Unfortunately, this dispute settlement system is not, and I emphasize not, tailored in the consequential way to accommodate the demands of community interest is the convention meant to serve. Positive aspects are that the system provides for compulsory settlement of disputes, and judges, and that is for me very important, are elected by states parties of UNCLOS and thus receive their legitimacy from the community of states. The same factor exists for the ICJs. But this factor does not exist for arbitrators. Arbitrators under Annex 7 to UNCLOS, as well as arbitrators under the environmental agreements, are selected by the parties. There is no legitimizing factor from the side of the international community. This reflects very clearly that these disputes are seen as bipolar disputes. The lack of community-induced legitimacy of arbitrators under Annex 7 to UNCLOS is aggravated by the fact that not the jurisdiction of ITLOS is compulsory, but the one of arbitration. For if parties don't agree on ITLOS, I'm quoting Article 289 of the Convention, then the fallback position and the mandatory regime is arbitration. One may say the distribution of competences between ITLOS and arbitration under Annex 7 constitutes a systems break from the point of view of legitimization of dispute settlement regime. Additionally, Part 15 of UNCLOS, in its first section, promulgates a number of limitations before recourse to compulsory judicial settlement is possible. All these provisions strengthen the role and the competences of the parties and neglecting the possibility that there are community interests involved. Let me come to the facts. Many of the judgments, awards or orders so far delivered by ITLOS are arbitral tribunals acting under Annex 7, touched upon interests of the international community, or at least a broader range of states, without this being reflected in the procedure concerned. For example, the decision on how to distinguish an island from a rock is not only a matter of relevance for the Philippines or China, but also for other states. It should be noted positively in this context, I want to underline that Indonesia changed its maritime boundaries by reference to this award. Equally, several of the judgments, orders, or awards concerning the management of fisheries or concerning the protection of the marine environment had implications beyond the parties to the disputes concerned. Even the land reclamation case between Malaysia and Singapore may be of relevance in times where sea level rise caused by climate change questions the sustainability of maritime borders. There was no involvement of the international community in this case. The rules concerning the possibility to intervene in a procedure before ITLOS are more flexible than the one before the ICJ. Nevertheless, this has never been used. Why not? I can only speculate. I believe the highly criticized decision of the ICJ concerning the declaration of intervention of the Republic of El Salvador in the case concerning military and paramilitary activities against Nicaragua may have had this negative effect. Another missed opportunity is provided for in Article 289, which stipulates that ITLOS may appoint at least 2 experts acting upon the application of the 2 parties or proprio motu to sit with a tribunal, however, with a vote in case required scientific or technical expertise. How often has this been used? 0, never so far. And there were ample opportunities to do so. In the cases dealing with the Bay of Bengal, we have a very particular situation in respect of the outer continental shelf in this area. The Continental Shelf Commission has not given its recommendation in this respect. Nevertheless, and I believe rightly so, ITLOS as well as the arbitration in the case Bangladesh versus India have done the delimitation, although, and taking into account the outer continental shelf. Although the Continental Shelf Commission has not given its recommendation, but it would have been wise and strengthened the cause if that had been done otherwise. I could continue on that, but let me switch on to further developments or the developments under the jurisdiction of the ICJ. In its already twice quoted order concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar, the ICJ constitutes the intermediate culmination of a series of previous decisions, such as the advisory opinion on the Genocide Convention, the obiter dictum in the Barcelona traction case, referring to ergo omnis obligations, evidently reacting to the correct criticism of to its decision in the second phase of Southwest Africa case. A further step into that direction was a statement in the already quoted question relating to the obligation to prosecute between Belgium and Senegal, to be followed by the order as indicated. One has to distinguish between the right to invoke by the applicant, a question to be decided on the merits, and the procedural question of standing. The former has its basis in the regime serving community interests, as already confirmed in the ICJ's in its advisory opinion. This substantive collective right found its expression in Article 48 of the ILC Articles on State Responsibility. This is firmly established. The step to establish the procedural right of the applicant's standing was accepted based upon the pragmatic argument of the ICJ that otherwise no state may invoke the responsibility. But I believe we can bridge the gap. One may add a further consideration. Based upon the Mavromatis clause, it is traditionally requested that the applicant claims an, and I emphasize again, individual right opposed by the respondent. In fact, in the context of the regime serving community interest, the applicant may claim its interest in upholding the integrity of the regime concerned, or to put it in different terms, that the commitments of the applicant to the international community or a particular community are not devaluated by the violations committed by the respondent. Let us not forget to uphold a regime such as the Montreal Protocol or the law of the Sea Convention or a human rights treaty. Every state has to contribute. And this contribution is weakened if others don't follow up to their commitment. It's particularly clear in respect of climate change. To sum up, on the question who may act as a claimant in judicial proceedings in defense of regimes serving community interests, the jurisprudence of the ICJ has demonstrated a high degree of responsiveness to modern challenges in international law. It is not only accepted that the regime serving communities' interests have a place in international law, but to be effective, deserve adjustments as far as judicial review procedures are concerned. The progressive development in this respect is best demonstrated by comparing the statements in the Southwest Africa case with the one in the case of questions relating to the obligation to prosecute or extradite. Whereas the former denies rights individual states may have in a regime which is qualified as serving community interests, the latter clearly acknowledges, and I quote, that any state party of the convention may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations ergo omnis parties and to bring that failure to an end of the quotation. But my contribution doesn't end at that moment. I have to come to a further point, namely the sacred principle that international judgments or awards only are binding for the parties and in respect of the conflict concerned. I'm referring to Article 59 of the ICJ statute or Article 33, paragraph 2, Annex 6 to UNCLOS, because that's a statute of UNCLOS. This clause is common. And it is a traditional clause, and we have it in national law too. As far as the regimes serving community interests are concerned, this clause does not seem to be adequate anymore. It rather reflects the traditional bifocal nature of legal disputes. A more differentiated ascertainment of the dogmatic basis of this clause and the relevant judicial practice of international courts and tribunals allows a more lenient approach thereto. I am now placing myself into a minority position, I know. Article 59 of the ICJ statute should be assessed taking into account the status of international court decision in international normative order and the jurisprudential practice thereto. According to Article 38, paragraph 1d ICJ statute, judicial decisions are subsidiary means for the detection of the rules of the law. They are not promulgating rights and obligations of states, but, and I quote, documentary sources, end of the quote, indicating where a court or tribunal can find evidence over the existence of the rules it is to apply. Although it is commonly emphasized that international courts and tribunals do not exercise legislative functions, international judicial decisions may, de facto, modify or supplement the international normative order. The dividing line between norm interpretation and the modification of an existing norm is a very thin line. Therefore, one could possibly argue that international courts or tribunals, when interpreting a norm, should not only take into account the interpretation of that norm by a judicial forum, but, as they actually mostly do, but to accept such interpretation if they have no convincing reason not to do so. This has been expressed quite clearly in the award Bangladesh versus India. And there it has also been said, and the background is, if you look into the law of the Sea Convention, what it says about delimitation, it's virtually nothing. We cannot set aside this jurisprudence which has been established by the ICJ, particularly in the Black Sea case. I would consider any judgment which basically denies the applicability of the procedure as established in the Black Sea case as being in violation of international law. I know I'm on dramatically very thin ground. Let me come to concluding remark. The contribution should have demonstrated that international dispute settlement system is tailored to decide disputes between two parties. This hangs on us like the eggshells of a hard-boiled egg. We have to get rid of them to some extent. This does not harmonize with the development of international law of establishing more and more regimes which are meant to serve community interests. So far, the attention on this aspect concentrates on who has standing. Those who insist that a state may only defend its individual rights before international courts or tribunals does not sufficiently take into account that a party to a regime serving community interests have a legitimate right to uphold the integrity of such a regime. The approach is being expressed in Article 48 of the ILC articles. Certainly, this is a provision on the merits. However, the consequences for the procedural side have been, let me say, mirrored in the order of 23 January this year, but this is actually too narrow, too specific an approach. We have two options to overcome that, or actually one. One is to revise the procedure of international courts and tribunals. I believe, and this is worth for further consideration, one should include into international adjudication that there is an attorney general defending the generality of international law. This should be introduced into international procedures. This attorney general should come in ex officio. I believe that indicates that I should finish. Give me 30 seconds. The alternative is that national courts will take over, or regional courts. We have now, in respect of climate change, the tendency that individual complaints brought before the European Court on Human Rights will deal with climate change efforts, not rights. This is not the job of a human rights court. This should be rather the obligation of an international court on the basis, however, of a procedure which is tailored accordingly. Thank you very much, and apologize for speaking too long.
No, not at all. You could have continued speaking, actually. And I have to say that this was really an extremely thought-provoking lecture. And I know that was the intent, because Judge Wolfrum is someone who really likes to push us to think. And I think that the issue of community interest is so relevant today. And you ended your lecture on climate change, which is the example par excellence of community interest. But what's so interesting is you took it from the dispute settlement aspect. I think often we're looking at it in a slightly different way, but giving us such a very compelling analysis of where the current dispute settlement system may not be adequate actually to protecting or giving the standing or the foundation for protecting the community interest. And then the idea of an attorney general ex officio, that is really, and I hope we have some comments from our participants. That's something that now will get me thinking as well, because, and let me see, do we have questions? Because if not, then I have some questions. While we let our participants think of their questions, let me then ask you, Judge Wolfrum, because as you know, we have a new implementing agreement that's being negotiated under the law of the Sea Convention. In short, BBNJ, the titles are too long, but for the conservation and sustainable use of biodiversity beyond national jurisdiction. This is the common interest, actually. And one of the questions that hasn't yet really been dealt with in detail, but in fact, we had a webinar recently on this, is dispute settlement. And so one point is to just adopt Part 15, mutatis mutandis. But now listening to you, I'm wondering maybe that's not adequate. So I would like to ask you, any thoughts on that? Is this an opportunity to actually implement this idea? Because this is the area of the common interest. So that's my question. And I also invite our participants, please, you have this wonderful opportunity to ask directly Judge Wolfrum your question. So that's my first question to you.
While the participant write down what they want to ask to your question, Nilufer, for me, in respect of biodiversity or genetic resources beyond national jurisdiction, I believe that these resources beyond national jurisdiction are the common heritage of mankind. Well, that answers in part your question as far as the substance is concerned. Now, the question is, how should we deal with that procedurally? You can either, you have two options, develop a new regime, which will be in competition with the International Seabed Authority. And the International Seabed Authority, I don't have to emphasize to you, is acting on behalf of mankind. Therefore, one option in this deliberations on the new regime should take into account whether or not to entrust the treatment, the management of these resources to the International Seabed Authority, which is already has a mandate to serve the common interests. That would be one very clear solution. Now you would argue that we would need the change of the law of the Sea Convention. I believe it would not. I believe it would be sufficient to have such a decision of the meeting of states parties, which could give an interpretation. And sure, it's a little bit besides the ordinary typology, but that would at least help for an intermediate period before an amendment would enter into force. The second alternative, which would take as long anyway, is to create a new regime, which is, however, also has the obligation to serve community interests, and not only the interests of certain coastal or other states. These two options we have, but I believe to say these resources are not the common heritage is not an option, for due to their very nature, they are. Actually, the, so to speak, the profits to be derived are not these genetic resources. They are the results, the scientific results achieved in looking into these resources, which are occasionally very strange, and this takes place already. Therefore, there is the interest to get some benefits from the further development. And this we have in the law, as far as deep sea minerals is concerned, we have that to a certain extent. And in this respect, we should have the same system, so to speak, for the genetic resources. That strengthens my view. Leave it all to the International Seabed Authority. I hope I have answered your question a bit, perhaps not to your satisfaction.
No. Thank you so much. No, that was a very clear answer. And I have to say that I probably have more agreement with you than disagreement. Although we could probably go on a little bit more about whether the existing role of the Seabed Authority is actually adequate to meet all of the community interests. But I see a question here. So Zifang, would you like to read us that question?
Yes, okay. Ahmad from Egypt has a question. His question is, do you think, Professor, that the Gambia and Myanmar case before the ICJ will be a turning point in the ICJ work? And Ankit from India also has a question. Ankit, the floor is yours.
Well, first of all, thank you, sir, for the wonderful lecture. It's quite, as Professor Oral said, it was quite thought-provoking. And borrowing from what Professor Oral said, my question was related to this dispute settlement mechanism and the effectiveness of the different mechanisms which are set out specifically under the UNCLOS clause. But I wanted to, since in the Australia Timor-Leste case you were so heavily involved in it, I wanted to ask you and get your opinion of why conciliation is not used as a deeper and a larger scale dispute settlement mechanism, because of just seeing the effectiveness of the award and the conciliation at Australia Timor-Leste. I feel that it should be used further, and I wanted to seek your comments and your opinion on this. Thank you.
I hope I understood the complexity of your question well. I will try to answer it. To what extent is international adjudication effective? You have your problem with the fact that international judgments of the ICJ or ITLOS cannot be enforced. But I tell you, from my own experience, and everybody will agree with me, that at the end of the day, these judgments are well enforced. Let me go, since you are from India, to the award between Bangladesh and India on the delimitation of the various maritime zones in the Bay of Bengal. This judgment has been 100% reflected in the Indian legislation as well as in the Bangladeshi legislation. And the other judgment of ITLOS between Myanmar and Bangladesh has also been fully reflected. Now, sure, you will tell me easily that, for example, in the case between the Netherlands and Russia in the on the Arctic platform case, said that it didn't care about the judgment. But the Arctic, the vessel, has been released. The crew has been released even before Christmas. And perhaps you have not paid attention to the fact that the Russians released the Russian members of the crew. This is, under international law, a huge concession. And therefore, there is no obligation to that extent under general international law to release your own citizens if they are accused of a criminal offense. Sure, I know, and I believe that's the gist of your question, that the judgment of the award in the case Philippines versus China has not been acknowledged by China. Right, so this happens. But I'm pretty sure if we talk to each other in 5 years again, you will see the effect of this award very clearly. I have, with some reason, mentioned the change of legislation in Indonesia. Sure, Indonesia was not a party, but Indonesia read the judgment, this award, and took consequences. And I believe the consequences you will see in the future in other states. And in a certain while, there will be an acknowledgement and a way out of this dilemma. Don't expect the judgments are automatically followed. This is not the international relations system. They are followed in a step-by-step procedure. One has also to respect the dignity of states. They don't want to confess they lost the case. You can see it. Even Trump doesn't want to lose.
Thank you. Yes, Ahmad from Egypt has a question. That first question was with respect to the significance of the Gambia and Myanmar case before the ICJ. Specifically, do you think that it will be a turning point in the ICJ jurisprudence?
Shall I answer directly? This was only a provisional measure. It was an order, the Gambia versus Myanmar. And I know that the Gambia has submitted its case on the merits. And I assume that there will soon be the response of Myanmar. But there is an old saying in international jurisprudence. This comes from the UK. I don't remember who brought it up. If you have a very weak case on the merits, try to be strong on the procedure. But you can turn that sentence around. The weak part was on the procedure, and I hope I established that. Now, since the provisional measure has established the jurisdiction, sure, not finally, the ICJ could come to a different conclusion, no doubt about it. But after this order has been accepted unanimously, I have my doubts. There will be dissenting opinions on the merits, for sure. But I believe that the case will go the way the Gambia was arguing. I would not bet a salary on that, but I'm rather reading the signs. I believe that this is going to be. You can call me when this case is being finally decided. And you will, please believe me, that Myanmar will follow and implement this decision. I have no doubts about that.
Thank you, Judge Wolfram. Evgenia from Russia also has a question.
Hello, dear Judge Wolfram, thank you very much for everything you said in the lecture, because it is very inspiring to know that things like an attorney general for standing for community interests is not just a dream of the youth, but something that seasoned professionals also believe can become true. And my question is about this proposal or this option or idea, is that whenever reading on general international law or the philosophy of international law, or on issues like sovereignty versus community-based or universal interests, there's always a difficulty in that community interests and values might not be as universal or as homogeneous as they seem to be. For instance, I think that the most stark example is that some people or even some whole communities might not believe in climate change. So if there were such an attorney general, how do you think the team, because I assume that would not be a single person, how would the team of such attorney generals reconcile the different understandings of the human values and interests involved, basically determining which values are universal and spelling out the natural law? Thank you.
Oops, this is a complicated question of yours. Natural law would require a long lecture. What is natural law? And I could start from Hugo Grotius or Pufendorf on that.
Well, maybe
law.
I'm sorry to interrupt. Maybe
I will not take an hour or so. Don't worry about it. But natural law requires a certain common basis of agreement what is natural law. And I'm referring to Grotius and Pufendorf. They developed natural law to get rid of the teachings of the Catholic Church. Don't forget that Grotius and Pufendorf were both Protestants. And therefore, for them, referring international law as being part and parcel of religion, in this case, the Catholic religion, was not anymore defensible. But don't accuse those scholars who did that. The religion, the Catholic faith, was a common understanding of the dominant European influenced world at that time. We don't have that common basis anymore, and it is rather difficult to establish it. Therefore, natural law is a positive dream, but if we both would try to come to an agreement, what is natural law in respect of a very concrete case, we would agree natural law would require the abolition of genocide. We have no problem in dealing with that. The abolition of piracy, slavery, torture, many of these things we can, but does natural law help us on the quotas for the emission of CO2 gas to protect the climate? The views in this respect are totally different, and we have no common basis. Therefore, a natural law works on a principled level, and even there, it doesn't work that well. You may not know, I'm heavily involved in Sudan at the moment. In the moment, there is a discussion there whether a state should be laïcistic or Islamic. We, coming from the West, Europe, and perhaps even you in Russia would say a state should have nothing to do with religion. But in this country, the view is totally different. We don't have the basis yet. This has fantastic consequences for the role of females, of children, and all these things. Yeah? And therefore, natural law is an aspiration, but we have not yet reached it. Koskemiani may take a different view in this respect.
Might I maybe follow up on this question just a little bit, because just to clarify it, I'm always up for a lecture on natural law, and I think my heart is with it. But the question was that exactly as you said, on very many things, we do not have a common basis. But to have an attorney general defending community-based interests, wouldn't that attorney general also require that basis in advance? So shouldn't states first agree on the common basis to then establish the office of the attorney general who would defend those interests?
It is, what you say is certainly correct, that we should strive for common interest, for common understanding, or a common ethical basis. I agree with that. But how do you do that? And in the moment, I'm highly critical about our politicians, who are very much state-centered in respect of that one state. America first doesn't help us very much in finding natural law. If all states would say Germany first, Switzerland first, then a common basis is missing. Or otherwise you should say the individualistic approach of states is a common understanding, but that doesn't help us much. Therefore, I am rather skeptical in the moment. What I would, however, I'm very pragmatic. Due to my age, I have the permission now to be pragmatic. Therefore, forgive me, and you have to be, being young, should be more romantic and dogmatic. That is totally okay. Even Churchill has said so. Therefore, you should bring your interest in natural law to bear in the communities you belong to. You will certainly have a positive impact, but others may argue, let's do it on a small scale, step by step, try to improve the common understanding. Perhaps we meet in the middle.
Thank you very much.
Thank you, Judge Wolfrum. Ahmad from Egypt has a question. Ahmad, the floor is yours.
Thank you, Professor, for this rich presentation and rich lecture. And I just want you to say that you have raised a very important point, saying that the ICJ judgments has an effect even on the long run. In that regard, I want to ask about do you think that even also the advisory opinion of the ICJ also has the same effect, giving in that context the ICJ opinion on the barrier wall that has been established between the Palestinians and Israel, and the ICJ advisory opinion said that it's not legal or it's illegal. Do you think that Israel one day will get rid of this wall to what you have, according to what you have said about the effect of the ICJ judgments? Thank you, Doctor.
Thank you very much for this. You are right. I may have mentioned the Wall advisory opinion, which is going into the same direction. Generally speaking, nearly all advisory opinion of the ICJ are in that respect quite forthcoming, and the Wall advisory opinion in particular so. And therefore, I did not mention it due to time restraints. I should have mentioned it and it fits into the sequence which I have shown. You're absolutely right. Whether it's going to be implemented one day or fully implemented, please forgive me that I am not able to respond to this question. I hope so, it will. But let me stop at that point, because it is more a political than a legal question.
Thank you. I think, unfortunately, we've come to the end of our time, but I think we had some very interesting questions from our students and participants, and thank you so much for your response. This has been really a fantastic lecture, and again, making us think, bringing in new thoughts. So you may be pragmatic, but I still think that you have a romantic side there with you still, Judge Wolfram, bringing in these new ideas and idealistic, according to some, but I think wonderful for us to think about, because the common interest has become even more important now. And climate change is one, the ocean is another. So it's a topic that we really have to think about more, and from a pragmatic aspect, as well as how to protect these common interests for the future generations. So we join on behalf of myself, Patricia as well, and the entire CIL team and our students. We thank you so much for this wonderful lecture, and we can only give you a virtual applause. But I do hope that we will welcome you back in Singapore and see you physically as well. So thank you so much, Judge Wolfram.